Ladies and gentlemen, this courtroom hearing starts out like a routine advisement and then completely spirals into one of the most chaotic self-representation disasters you'll ever see. Today's defendant, Matthew Capori, walks into court facing a mountain of charges, multiple traffic cases, misdemeanor cases, and now 2 brand new felony vehicular eluding charges. According to prosecutors, this wasn't just a misunderstanding or a paperwork issue. They claim Capori knowingly fled from law enforcement on 2 separate occasions while driving recklessly and while his license was already under restraint. And somehow, despite the seriousness of those allegations, he decides this is the perfect moment to represent himself. Now, if you've watched courtroom videos before, you already know where this can go. The moment someone starts talking about special appearances, challenging jurisdiction, and refusing to recognize the authority of the court, judges immediately go on alert. And that's exactly what happens here. What makes this hearing fascinating is that the judge actually gives him multiple opportunities to slow down, understand the charges, and reconsider waiving counsel. But instead of focusing on defending himself against serious felony accusations, Capori becomes laser-focused on arguing constitutional violations, jurisdictional claims, alleged due process issues, and the seizure of his vehicle. And here's the part you don't want to miss. The judge starts out extremely patient, calm, professional, even accommodating. But as the hearing progresses, you can see the court slowly realizing this defendant may not fully understand the legal situation he's in. Meanwhile, prosecutors are arguing that he represents a danger to the community because of repeated felony eluding allegations, and the court has to decide whether bond conditions should remain in place. The biggest twist? By the end of this hearing, the same judge who initially allowed Capori to represent himself suddenly changes course and reappoints the public defender anyway. That moment alone tells you everything about how this hearing unfolded. So, the big question for everyone watching is this: was Capori genuinely trying to defend his constitutional rights, or was he sabotaging his own case by turning the hearing into a jurisdiction battle instead of addressing the actual charges? Watch closely, because every answer the judge gives here reveals how courts handle sovereign-style arguments when serious criminal allegations are on the table.
Intimidating, retaliating against, or tampering with any witness to or victim of the acts charged. If your cases involve domestic violence, you're prohibited from having contact if already ordered. I will let you know that there have been 2 additional cases that I don't know if you have been advised on. The first of them is 26 CR 5. 26 CR 5, the district attorney filed a felony complaint and information indicating 3 charges. Count number 1, vehicular eluding, a class 5 felony that on or about December 29th, 2025, Matthew Mark Capori, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempted to elude Jonathan Roy and or Austin Minicho Sikora, a peace officer also operating a motor vehicle, when the defendant knew or reasonably should have known that he was being pursued by the peace officer and operated his vehicle in a reckless manner. That carries a possible penalty of between 1 and 3 years in the Department of Corrections. Count number 2, driving under restraint. On or about December 29, 2025, Matthew Mark Capori unlawfully drove a motor vehicle upon a highway with knowledge that the defendant's license or driving privilege was under restraint in violation of sections 42.2, 138, 1A, carries a possible penalty of up to $100. Count number 3, reckless driving. On or about December 29, 2025, Matthew Mark Capori unlawfully drove a motor vehicle or a low-power scooter in such a manner as to indicate a wanton or willful disregard for the safety of persons or property in violation of section 42.4, 1401 CRS that carries a possible penalties of up to $300, up to 90 days in jail, or both. In 26 CR 10, the district attorney filed a felony complaint and information in that matter, alleging 3 charges. Those 3 charges read the same, but they indicate that they were on January 14th. Count 1, vehicular eluding. On or about January 14th, 2026, Matthew Mark Capori, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempted to elude Deputy Brett McWilliams, a peace officer also operating a motor vehicle, when the defendant knew or reasonably should have known he was being pursued by the peace officer and operated his vehicle in a reckless manner in violation of section 18.9.116.5 CRS. And then, like the other charges I read to you, it also includes a count of reckless driving and a count of driving under restraint, both alleging that it occurred on or about January 14th of 2026. Do you understand the charges in those two cases as I've read them to you?
This right here is the exact moment the judge realizes he may be dealing with a defendant who's in way over his head. The court just spent several minutes carefully explaining the felony charges, including vehicular eluding, reckless driving, and driving under restraint. And when the judge asks if he understands them, Capori flat out says no. Now, legally speaking, that answer matters a lot more than people think. Courts cannot allow a defendant to waive counsel unless that waiver is knowing, intelligent, and voluntary. In other words, the judge has to believe the defendant actually understands what he's doing. But instead of clarifying confusion about the criminal allegations, Capori immediately pivots into special appearance language and jurisdiction challenges. That's a huge red flag in court, because judges hear these arguments constantly from sovereign citizen-style defendants who believe certain phrases can somehow exempt them from criminal proceedings. Spoiler alert, they don't. And notice the judge's tone here. He's still trying to help. He's warning Capori that criminal law is complicated and that self-representation is dangerous, especially when felony exposure includes possible prison time. Yet Capori keeps pushing forward anyway. What do you guys think? Should judges step in sooner when defendants clearly don't understand the legal system, or should people always have the unrestricted right to represent themselves no matter how badly it may go?
But in regards to those cases, do you understand that Ms. Villalobos would represent you in those cases?
I would like to waive my right to counsel in those cases as well.
Understanding that you do have the right to remain silent, you do have the right to have an attorney. Well, let me just ask a little bit more regarding your right to counsel. You state you do understand your right to have an attorney and you wish to waive it for today. Is that correct?
That is correct.
When you waive that right, well, is this your knowing and voluntary decision?
Yes.
Are you under the influence of anything?
No.
Are you thinking clearly?
Yes.
Has anybody made any threats or promises to get you to do this today?
No.
Do you understand that I will appoint counsel if you want an attorney to represent you?
Yes.
Do you understand the charges that I indicated on those two cases, and that the other cases involve charges that include possible jail time in the county jail? Do you understand those possible penalties, including up to 3 years in the Department of Corrections in both of the new felony filings? Do you understand those possible penalties?
Yes.
Do you have any legal training?
I do not. No.
How far have you gone? How far have you gone in school? Do you understand criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Yes.
Do you understand that that while you have the right to represent yourself, but that by doing so, you take a great risk of not properly presenting your case or your arguments?
Yes.
For this hearing, at least, knowing all of this, is it still your desire to represent yourself?
Yes.
All right. I think a couple of things we need to do. I've advised the defendant on the charges, Ms. Decker, and so I think on those cases I need to ask him how he wishes to go forward, whether he wishes to have a preliminary hearing on those matters and have those set for it. I do think we need to address bond in at least some of the cases, and he does have the right to have a 48-hour bond hearing in those charges, or he does have the right to have a bond hearing in regards to those new cases at least, and some of the traffic offenses.
And there it is. The courtroom takes a hard turn into full jurisdiction challenge territory. Notice how Capori starts stacking together phrases like special appearance, writ of habeas corpus, Rule 43, illegal black hole, and due process violations. To someone unfamiliar with courtroom tactics, it can sound incredibly technical and persuasive. But here's the reality. Using legal terminology doesn't automatically create a valid legal argument. The judge and prosecutor immediately focus on something much more practical: prejudice. Capori keeps arguing that his bond hearing happened outside the 48-hour timeline, but the prosecution explains why that issue may not actually help him legally. Since he was already serving a separate 120-day jail sentence, the delay allegedly didn't create additional prejudice against him. That distinction is critical because courts often look at whether a delay caused actual harm, not just whether a technical deadline was missed. Then there's the vehicle seizure argument. Capori claims his vehicle was searched before a warrant was issued, raising potential Fourth Amendment concerns. Now, unlike some of the jurisdiction arguments, that issue could potentially become a real evidentiary dispute later if properly litigated through motions and hearings. But here's the problem. He's presenting everything at once in a scattered way instead of strategically focusing on the strongest possible legal issues. This is exactly why judges repeatedly warn defendants about self-representation. Knowing legal buzzwords is not the same thing as knowing courtroom procedure.
With a search warrant dated April 8th from a looks like a senior judge in Jefferson County to seize my vehicle and some property in it. But this warrant was dated 8 days after it was actually searched and seized. It was searched and seized April 1st, forcefully from me in Aurora on private property. I was held at gunpoint and arrested, and that's when the vehicle was taken. There's no chain of custody between that day and April 8th when this warrant is dated. I don't know where it was. I assume it was in the hands of the Gilpin County Sheriff's Office. There's no record of what was done in between. It was not impounded. It seems like they just took it and had it dropped off in their own parking lot. So there's no record of what, of anything in between the day they actually searched and seized it and the day they got a warrant to search and seize it. That is a clear due process violation under the 4th, 6th, and 14th Amendments of the United States Constitution. I would like an explanation for all of that today, first off, and because of those violations.
We can set all those matters for a hearing. I'm going to advise you again, Mr. Capori. I don't know if you want to talk about these facts and these situations today. As I mentioned, there's two things we're going to address. We're going to address whether or not bond should remain as set, and we're going to address what your next court date's going to be.
Okay,
do you wish to address the court regarding either of those questions?
Well, why was the 48? Why are we 31 days past the 48-hour mandate for bond setting?
And Judge, may I withdraw?
Yes, Mr. Guillen, thank you for your time.
Thank you.
And
so you're complaining that it was beyond the 48 hours, correct?
Yes, we're 31 days past that currently.
Anything else?
For me?
Yeah, any other argument regarding bond?
Well, I'm challenging that the court has no jurisdiction. I said that I do not consent to this video appearance per Rule 43. I have a right to be there in person. And I would like the immediate release of my vehicle that has been stolen from me.
All right, I don't have any authority over that. I have authority right now over these criminal matters.
Okay, I would like an explanation why there's a 31 delay on my bond hearing and my Rule 5 advisement pursuant to...
At this point, the hearing becomes a tug-of-war between practical courtroom procedure and Capori's insistence that the court lacks jurisdiction altogether. And honestly, the judge's response here is pretty telling. When Capori argues that everything should stop until jurisdiction is proven, the judge immediately shuts that down and explains that the court has already found probable cause, issued warrants, and lawfully filed the cases. From the court's perspective, jurisdiction is already established. But here's where things get interesting. Even while rejecting Capori's arguments, the judge still grants him something important: an in-person preliminary hearing. That's significant because preliminary hearings allow the defense to challenge whether probable cause actually exists for felony charges. So ironically, while Capori keeps arguing broad constitutional theories, the judge is quietly giving him an actual procedural avenue to challenge the prosecution's evidence the proper legal way. And then comes the turning point. The judge decides to appoint the public defender again, despite Capori insisting he can represent himself. Why? Because the court clearly starts doubting whether Capori truly understands the risks involved. Judges have a constitutional obligation to protect a defendant's rights, even when that defendant is actively making the process harder. The irony here is incredible. Capori spends the entire hearing arguing that the court has no authority over him, while simultaneously relying on that same court to enforce his constitutional protections. Would you trust yourself to fight multiple felony charges alone in court, or would you take the lawyer every single time?
Currently serving a 120-day jail sentence, and was addressed then that there is no prejudice in regards to this matter. I am going to deny modification of the bonds on the 26 CR 5, 26 CR 10 case. Those are the largest of the two bonds. Here's where I do have to, by statute, modify bonds. Okay. On 24T317, that will be modified to a personal recognizance bond.
I'm sorry, what was that case number, Your Honor?
24T317.
Thank you.
24T75, 24T392, 24T275, and I can update all these for you, Jetta, when I get to them. 275, sorry. The 25T53 and 25T108. All of those cases, all those bonds in those 6 cases will be modified to personal recognizance bond. The court denies modification of any other bonds at this time. Mr. Capori, do you wish to have a preliminary hearing to test probable cause in the 2 new felony charges?
Your Honor, I am solely here to challenge the jurisdiction of this court. That's all in the due process violations are unconstitutional.
The court finds that it does have jurisdiction over these cases. These cases were filed here. Affidavits and arrest warrants were issued out of this court. The court finds probable cause and does have jurisdiction. Your next argument.
How does the court can determine its own jurisdiction? Is that correct?
No, I made a factual finding. I have jurisdiction, and I made so in each of those cases.
Okay.
Do you wish to have a preliminary hearing? You must demand. You said you didn't want to waive any of your rights. What I'm going to do is I'm going to set you for a preliminary hearing. I'm going to ask that the district attorney writ you to be here in person as you have requested to be here in person. Let's do that June 1st date.
1:30.
June 1st, 1:30 for preliminary hearing. All other matters will be set for a continued arraignment. Mr. Capori, you said that you waived your right to an attorney as for today. Is that, yes. Do you wish?
I don't consent.
This hearing perfectly demonstrates the collision between constitutional rights and courtroom reality. Matthew Capori entered court determined to challenge jurisdiction, argue due process violations, contest the seizure of his vehicle, and represent himself against multiple criminal charges, including 2 felony vehicular eluding cases. But throughout the hearing, the judge repeatedly tried to redirect the focus back toward procedure, evidence, bond conditions, and the actual criminal allegations pending against him. In the end, the court denied modification of the major felony bonds, scheduled a preliminary hearing, rejected the jurisdictional challenges, and ultimately decided that appointing counsel was necessary despite Capori's objections. And honestly, that final ruling may become one of the most important moments in the entire case, because whether viewers agree with Capori or not, this hearing showed how quickly self-representation can spiral when legal theories start replacing practical defense strategy. The broader takeaway here is simple. Courts will absolutely hear constitutional arguments, but they expect them to be raised through recognized legal procedures, supported by coherent motions, evidence, and proper courtroom conduct. Simply declaring that the court lacks jurisdiction rarely stops a criminal proceeding in its tracks. Now we want to hear from you. Do you think Capori was genuinely standing up for his rights, or did he damage his own case by refusing to work within the legal system? Drop your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.